Good evening, everyone. I'm honored to welcome you all on behalf of Center for Study and Research in Intellectual Property Rights to this insightful online lecture on trademark infringement in the digital era, issues and challenges. Today we have the privilege of hosting a distinguished speaker, Dr. Atul S, Jaybhaye, who brings a wealth of knowledge and experience in the field of cyber law, criminal law, and intellectual property rights. Dr. Jaybhaye is an assistant professor of law at Hidayatullah National Law University, and his academic journey is marked by excellence, having received a meritorious student award at the LLB examination. With more than 7 years of expe- experience, he has served as an assistant professor for 3 years at the Government Institute of Forensic Science, Aurangabad, and also contributed to the academic environment at Alliance School of Law, Bangalore. His practical insights are enriched by a 2 year experience practicing in both High Court and District Court at Aurangabad. At HNLU, Dr. Atul imparts knowledge in the domains of cyber law, criminal law, and intellectual property rights. His dedication to research is evident through the numerous research articles he has published, as well as the research papers he has presented in various seminars, workshops, and conferences. Today, we are fortunate to have him to shed light on the complex issues surrounding trademark infringement in the digital era. His expertise in this area promises to provide us with valuable insights and perspectives on the challenges that arise in safeguarding trademarks in the rapidly evolving digital landscape. Without further ado, let us extend a warm welcome to Dr. Atul S. Jaybhaye and eagerly anticipate the enlightening lecture he is about to deliver. Thank you, sir, for your presence.
Thank you, Archita. So, at the outset, I take this opportunity to thank the Center of the IPR and Organizing Committee of NUSRL Ranchi for inviting me for this lecture, that is trademark infringement in the digital age. So, let me share my screen first. Slide is visible, Archita. Hello. The slides are visible.
Yes, sir.
Okay, so shall I start?
Sure, sir.
Okay. So the topic which has been allotted to me, that is the trademark infringement in the digital era, issues and challenges. If you see, we are living in the age of information technology, and there are various challenges in this digital age. And one of the challenge is the violation of intellectual property rights in cyberspace. So before going into the depth of trademark issues in cyberspace, let us try to understand first the concept of intellectual property in brief. As you might be aware that intellectual property is a creation of the human mind intellect, wherein he puts a lot of efforts for creation of this intellectual property. And there are various types of intellectual property, that is copyright is there, patent, trademark, and so on. So trademark is also one of the essential types of intellectual property, and for which in India we have the Trademark Act, which has been enacted by the Parliament of India in the year 1999. So similarly, there are other legislations also, that is Patent Act, Copyright Act. All these legislations provides a procedure for registration of intellectual property, etc. It also provides for remedies for infringement of intellectual property. However, now also there is a growth due to the growth of e-commerce and social media.
Pardon to interrupt, sir. Your slides are blank.
Blank. Okay. Is it visible now? It is still
No,
blank.
sir. It is still a blank screen.
Which icon should I click to share the screen?
So there
present
must be
and
a present option.
the slides, computer, load file. It is uploading. The slides are uploading. That is one option. Another option.
Another option is to share your screen, sir.
Sharing the screen.
Yes, sir, it is visible now.
It is visible? Right.
Yes, sir.
Okay, so I was in this slide. Yes, so we are discussing this due to the growth of electronic commerce. E-commerce is nothing but buying and selling the goods in an online mode, as well as there are also various issues wherein the intellectual property is also violated on social media, maybe by using any logos, etc. So there is ultimately a threat to the intellectual property rights in this digital age. Moving to the next slide, if you see the definition of trademark that is given under section 2 subclause 1ZB of the Trademark Act 1999, which reads as trademark means a mark capable of being represented graphically. So first, it should have a graphical representation. That is the first condition which has to be fulfilled for a registration of trademark, and also which is capable of distinguishing which is also capable of distinguishing the goods or services of one person from those of others, and may include the shape of goods, their packaging, and combination of colors. So it consists of any logo, symbol, signs, marks, etc. Even as you can see in this slide, even any combination of color, even a shape of goods can also be registered as the trademark. And that's why one of also another ingredient is that there shall not be any deceptive similarity between the two marks, so that consumers there shall not be any confusion among the consumers. After that, the trademark also has few functions. It identifies the product and its origin. For example, take an example of this uh, Amazon, etc. So that is a trademark. So we are well known that is an e-commerce website or a trademark. Also, it distinguishes the product or services of the proprietor from those of others. It should clearly make a distinction between the goods or services of one person from those of others. Then only it can be registered as the trademark. It also guarantees its quality. That's why often we want to buy the branded products or products which are of the high quality, etc. Also, trademark advertises the product or service. Now, the trademark owner take a lots of effort because he has created that trademark, and he has also earned a goodwill or reputation in the market. And that's why he thinks that without his permission or consent, no any other person has a right to use that trademark, maybe in relation to similar goods or dissimilar goods or services in the market. Also, it creates an image of the product in the minds of the consumer over a period of time, so that we don't forget maybe the well-known trademarks, let it be a Parle-G, etc., Colgate, which you have been using since years to years. Now, let us try to understand the modes of infringement of trademark in cyberspace. Now, till now, we have understood the definition of trademark. It may include a shape of goods, combination of color, etc. However, a trademark is infringed in cyberspace. Cyberspace is nothing but a virtual world, an online platform. So there are two modes which I am going to deal with. First, the cyber squatting, and second is the counterfeiting of goods in e-commerce. Because if you see in the e-commerce website, there are also certain counterfeiting goods or trademarks which are being used and sold. So whether the e-commerce website will be held accountable or not, or what are the liabilities, responsibilities of the e-commerce website, that has to be looked into. Now let us try to understand first what is cyber squatting. Cyber squatting is nothing but a practice of registering a domain name in bad faith, which is likely to be desired by an entity, company, or organization with the intention of selling it for profit to another person, company, or organization is known as cyber squatting. And the person who commits such offense, those persons are called as the cyber squatters. It includes the third parties that do not own the trademarks or trade names but still register a domain in their names. And in this case, there is a malafide intention or a fraudulent intention to cause the confusion among the public. Now, why a person commits this offense? Because fraudulent intention is there, malafide intention is there. He wants to divert all the consumers to his website or a domain name which he has created in a bad faith. Now, to get a better understanding of this concept of cyber squatting, first we'll have to understand a concept of domain name. As you can see in this slide, a domain name is nothing but an IP address, a name which is assigned to a particular website. Here I have given one example, www.tata.com. So here Tata, that is known as the second level domain names, because also there are different types of domain names, that is second level domain, top level domain. So dispute arises with respect to this second level domain names, that is Tata, and .com, that is a top level domain names. Now let's take an example. If any person, XYZ person, is carrying on business and he has launched a trademark in the market and he has registered his trademark with the trademark registry. However, he is not running any business through any e-commerce website, etc. And then another person comes and he copies that particular trademark and register it as a domain name in an e-commerce website. And he is also providing the same types of services, etc. Then there is a possibility of confusion among the consumers, because consumers may feel that this particular domain name which has been created with a dishonest intention by any third party, it is somewhere associated to that particular genuine trademark, but actually that is not the fact. And this is the way wherein the dispute arises between the trademark and domain name in cyberspace or in a virtual world. Now, as I said that there are different types of levels of domain names. First is the generic top level domain names. As you can see in this example, .com, which is used for any commercial purposes. Also, you can see any domain names, top level domain names, .org, that is organization. Even educational institutions, they use the domain names, that is .edu, then .government, .net. Similarly, these are 7 generic top level domain names which are being used in the cyberspace. And as I said that the dispute arises with respect to second level domain names. Now here I have given one example, that is www.amazon.com. Now Amazon, it's a trademark as well as it's a domain name also. Now let's take an example. If I create a fake website or domain name by making any slight changes in the spelling of the Amazon. For example, if I add one more letter of A or maybe letter of N at the end, and I get this domain name registered. So it may happen that the customers, the netizens, internet users, instead of reaching to a genuine website of www.amazon.com, they may reach to my website wherein I'm also selling the same products, maybe some counterfeiting goods, etc. So my intention is a malafide intention here, and that's like a domain name which I have created in a bad faith with dishonest intention. So there can be a dispute between trademark and domain names, or there can be a dispute between domain names themselves. And third category of domain name is country code top level domain names. As you can see few examples here, it tells us that from where the website originates. For example, .in, it means it originates from India. .ca, that is, it originates from Canada, then .us, it originates from US, and so on. So this we have to keep in mind before yes, before going into the details of case laws with respect to cyber squatting. So I hope that you understood the concept of cyber squatting, where a person creates a domain name in bad faith with dishonest intention, and then he tries to sell that domain name to a genuine trademark owner. So he blackmails him that you purchase this domain name from me. So that is known as the cyber squatting. Now there are few case laws or judicial pronouncements with respect to an act of cyber squatting. So the first landmark case is, as you can see in this slide, that is Yahoo versus Akash Arora. This is the case of Delhi High Court. Now, why this case is important? Because this is the first case in India relating to violation of domain names. Because this is the emerging issue of the domain names. There is a often violations of trademarks, but violation of domain names in cyberspace. So this was reported as the first case. So in brief, I will tell you the facts of the case as you can see in this slide. Akash Arora, who is the defendant in this case, is started to offer web-based services similar to those offered by Yahoo.com. Now we know that Yahoo is a well-known mark and it's also a domain name. Yahoo.com under the name Yahoo India. Now the defendant Akash Arora, he only added one suffix, that is India. Now you see there is a deceptive similarity between Yahoo.com and Yahoo India. So a person may feel that Yahoo India is also owned by this entity or company, that is Yahoo.com. And that was the intention of creating this domain name in bad faith, YahooIndia.com. And that's why the genuine owner, that is Yahoo Incorporation, then they filed a suit against this defendant, Akash Arora, for using a trademark which is deceptively similar to its own trademark and passing off his services as those offered by Yahoo Inc. If you see, one of the principles of trademark law is that no person has the right to pass off the goods as those of others. So passing off action is also prohibited under the trademark law, so as to avoid the confusion. So Yahoo.com, it had been registered by Yahoo Incorporation with Network Solutions Inc. since 1995. So they have been carrying on the business, they are in the market since 1995 and offers a whole range of web-based services. So they put up all these evidence before the Delhi High Court, etc. And name Yahoo has also acquired a reputation and a goodwill in the market and public at large. That's why the court came to the conclusion that Yahoo is the genuine owner of this domain name, and defendant has created this domain name with a dishonest intention, with a fraudulent intention to encash upon the goodwill and reputation of the Yahoo Inc. And that's why the injunction, that is a permanent injunction, was granted in favor of the Yahoo Inc. And the court asked the defendant not to carry on or to cancel this particular domain name, that is Yahoo India, so that there shall not be any confusion among the internet users. Then moving to another case, that is Satyam Info versus Sifnet Solutions. Now this is the case of Supreme Court of India of 2004. So Satyam, as we know, that is also a well-known mark when it comes to computers, technology, etc. So Satyam Info, they are the appellant in this case, the genuine trademark owner. Name by registering deceptively similar domain name as Sifinet.com. Now, as you can see in this slide, the Sifinet.com, this domain name is registered by Sifinet Solutions. And as you can see, they are also using this particular term Sifi, which is being used by Satyam Infoway since years together. And that's why they filed a suit. The case reached to the Supreme Court. I'm not going to deal into the details only in brief that I have given the judgment in this case. So one of the pertinent issue before the Supreme Court was that whether the domain names are entitled to same protection as the trademark or not. Because if you see in India, there is no any comprehensive legislation in India with respect to protection of domain names. And there were very like first instances wherein the domain names were where the trademarks were violated by creating domain names in bad faith. That's why the Supreme Court relied on the provisions of the Trademark Act 1999, and the court said that though there is no any legislation, but the domain name it serves the same function as the trademark, and that's why it is entitled to the same protection as the trademark. The Supreme Court held that appellant was entitled to injunction order and restrained the respondent from using domain names in dispute. So in this case also the relief was given in favor of the Satyam Info. But before giving the relief, the court has to see that whether there is any prima facie case, whether there is any balance of convenience, and whether there is any irreparable loss which could be caused to the plaintiff in case the injunction is not granted. So these three conditions has to be fulfilled. That is prima facie case, balance of convenience, and irreparable loss. Then and then only the court can give or pass an order of the injunction in favor of the plaintiff. Then similarly, in another case, that is Tata Sons versus Arno Palman and others. So these all cases are related to an act of cybersquatting where the trademark is violated or infringed in cyberspace by creating domain names in bad faith. Similarly, Tata is a well-known mark, which is actually a surname. As you know, under the trademark law, surname as such are not registered as the trademark, but if it has acquired the distinctiveness in the market over a period of time, then in certain cases it can be registered and protected. So in this case, the suit was filed for restraining the defendants from using the trademark or domain name, that is www.tatainfotech.in. Now the Arno Palman, they are the defendant in this case, and as you can see, they have created this domain name Tata Infotech without taking any permission of the Tata Sons. And word Tata derived from surname and it has been registered as trademark. It comprises of over 50 companies which uses the word Tata. It is also pioneer in the field of information technology, and they have been using this Tata Infotech since 1997. So they are also prior user when it comes to the use of trademark in the market. And the defendant could not give any justification before the Delhi High Court that why he has created this domain name tatainfotech.in. He could not give any reasonable justification in his defense. So the defendant had sent the mail to the plaintiff and blackmailed them to purchase the domain name. So these are the activities where the defendant tries to sell this domain name to the plaintiff. But as the Tata Sons, it is also financially sound. So instead of purchasing this domain names from the defendant and not to become the victim of blackmailing, they rather opt to go before the court. And therefore they filed a suit, and also in this case also the injunction was granted in favor of the Tata Sons. Then in another case, that is Aqua Minerals Limited versus Mr. Pramod Borse, case of 2001, Delhi High Court. Bisleri is also another well-known mark. It is one of the landmark judgments on the cyber squatting cases in India. Bisleri as a brand and a well-known trademark of drinking water that we have been drinking water of the Bisleri since years together. So the defendant in this case deliberately registered. See, now the Bisleri by that time they did not register any domain name, and the defendant had taken the undue advantage of the same. So he registered the domain name, that is bisleri.com, as its domain name. And when the plaintiff got to know about this, that is Aqua Minerals Limited, who is the genuine owner of this trademark Bisleri, they filed a suit for injunction. So they might have put a lot of evidences, documentary evidences, maybe about their advertisement, etc., carrying on the business with respect to Bisleri over a period of time. it has earned the goodwill and reputation in the market. There is a malafide intention on the part of the defendant to divert all the consumers, etc., in cyberspace. Therefore, the court granted the injunction, holding that domain name serves the same function as the trademark. So, this is the important observation of the Delhi High Court, that domain name serves the same function as the trademark, and therefore it is entitled for the protection under the Trademark Act of 1999. Then another case, that is Rediff Communications versus Cybertooth. So you see how the defendants, they are creating deceptively similar domain names, or they are directly copying the name of the trademark which is actually being registered with the trademark registry. So this is another example wherein the defendant has made slight changes the name of the trademark itself and has created the domain names. As you can see in this slide, you can see the name of the rediff.com and Radiff. So he has only added one letter A instead of E. The name of the case is Rediff Communications versus Cybertooth. This is a case of Bombay High Court 2000. In this case, plaintiff Rediff Communication was an online media company carrying on the business of communication and providing services through the internet. And the defendant was also providing the same services. Even that we have to see that whether the defendant is also carrying on the same business or not, because many a times defendant takes a plea that he is not providing same services, or he has registered that trademark on domain names in different classes of goods and services, etc. So in 1997, the plaintiff registered the domain name rediff.com with Network Solutions Inc. This is the agency, Network Solutions Inc., through which domain names can be registered, as we also discussed under the Yahoo versus Akash Arora. They had also registered the Yahoo domain names with this Network Solutions Science Incorporation. So in March 1999, after 2 years, the plaintiff learned that defendants have obtained the registered the domain name radiff.com. And plaintiff filed a suit for permanent injunction, and the court came to the conclusion that there is a possibility of confusion, and accordingly, the court also granted the injunction in this case. So, as you can see, in most of the cases, a relief is given in favor of the plaintiff by upholding the interests of the genuine trademark owner. Also, Z Telefilms versus Z Kathmandu. Z is also a well-known trademark. This is also a case of Delhi High Court of 2006. Here is the plaintiff filed a suit for permanent injunction restraining the passing of action in respect of domain name. Now see, the defendant has created several domain names and he has used the term particular Z in his domain names. And it leads to acts of unfair competition. It also leads to dilution of trademark, rendition of accounts, etc. So as the domain names of the defendant were identical to the plaintiff's channel names, and plaintiff had a reputation in the fancy trademarks Z since 1992, the court found that the object of the defendant in registering the domain name was only to use the goodwill of the plaintiff. Now, what is the goodwill? It is not earned in a day. It takes several years for the trademark owner to earn a goodwill with respect to his goods or services, where he puts a lot of efforts, etc. And then he earns a goodwill or reputation, so that he may feel that this goodwill or reputation shall not be infringed by any other person. So in this case also, the defendant was injected from using the disputed domain names. Now, after discussing this case, another question arises, that is there any law of cyber squatting in India or not? As we discussed till now, that how the trademark is violated in cyberspace by creating domain names with dishonest intention in bad faith. So in India, there is no law which can provide protection for domain names. So cases of cyber squatting are settled under the Trademarks Act of 1999. Now, as here we are talking about the trademark infringement in the digital age. So we will also have to see that whether Information Technology Act, whether it addresses this issue or not. So even the IT Act, Information Technology Act of 2000, it is also silent on this issue. It does not address any issues with respect to cyber squatting or maybe any violation of intellectual property in cyberspace. That's why I feel that there is a need that the India should enact a comprehensive legislation similarly to that of United States, because US have enacted a separate legislation, as you can see in this slide, that is Anti-Cyber Squatting Consumer Protection Act, which was enacted in the year 1999 in an attempt to prevent cyber squatters from registering internet domain names containing trademarks for the purpose of selling those domain name back to the trademark owner. Right. Then now what if how to resolve these disputes of trademark and domain name? So this is the UDRP policy, that is which is known as Uniform Domain Name Disputes Resolution Policy, which is known as UDRP, through which domain name disputes can be resolved. It was launched on 1st December 1999. The plaintiff, he can also go to the court or he can also resolve his disputes through this UDRP policy, which is very cost effective and which is very wherein the it will not take years together for resolution of any dispute. So it is a process established by the ICANN, which is known as Internet Corporation for Assigned Names and Numbers, for the resolution of disputes regarding the registration of internet domain names. One of the main purpose of the UDRP is to provide a quick, cheap, and easy means to adjudicate domain name disputes between trademark holders and bad faith registrants of the domain names. So as I said initially, this UDRP will also go into three things before giving the relief in favor of the plaintiff, that whether there is any prima facie case or not, whether the plaintiff is the genuine owner of the trademark or domain name or not. Balance of convenience, whether it lies in favor of the plaintiff or defendant, that also the arbitrator of this UDRP that he has to see. And in case the injunction is not granted, then it may result into irreparable loss. So the burden of proof, it is on the plaintiff in this case or the complainant. So comparatively, this is cost effective, through which the domain name disputes can be resolved. Now, having discussed that, cyber squatting, the another mode of infringement in cyberspace is trademark infringement in electronic commerce. Electronic commerce is nothing wherein we buy the goods in an online platform and the goods are delivered at our doorstep. So counterfeiting of the goods or trademarks is one of the major concerns in the digital age. But now, due to the growth of this technology, due to the growth of artificial intelligence, etc., e-commerce, there is also threat to the trademark, wherein the sometimes counterfeiting goods are being sold and it causes a financial loss to the genuine trademark owners. Now, these e-commerce websites, they act as an intermediary. Now, what is an intermediary? That has been defined under the Information Technology Act. For example, search engines, they are the intermediary. Or in cyber cafe, it is also an intermediary. In e-commerce website, it is also an intermediary. So these websites acts as an intermediary between the buyer and seller for the purpose of being as a virtual platform to buy and sell the goods. The e-commerce website gives the authority to anyone to buy and sell the goods in online, but meanwhile, many trademark infringements occurs in e-commerce websites because of the non-verification of the authenticity of the goods. Whether the goods are authenticate or not, trademarks are authenticate or not, even that has to be seen by these e-commerce websites. So it is the legal duty of the e-commerce websites to follow the laws relating to due diligence obligation of various countries to prevent the counterfeiting goods from being sold. Infringement of trademark in the e-commerce, now why it is so much essential or crucial, because it hampers the growth of the internet, web-based business and computerized economy. Now today we are talking about the artificial intelligence. It may have certain advantages, etc. but it may have certain disadvantages or limitations also. So this buying cycle structure is evolving once more with the presentation of the AI applications. For example, Amazon Alexa, Google Home, buyer chatbots. These are all the AI, artificial intelligence, which also are being used in the e-commerce websites. So Amazon Alexa, it prescribes three items to the purchaser when provoked to look for an item to purchase. Sometimes the buyer doesn't know about the full scope of the items. Then this AI application again shapes a channel between the buyer and the brand, which may be an original one or it may be a duplicate one with the trademark infringements. It becomes difficult also to identify. And that's why there is a possibility that counterfeit goods or trademarks are also being sold. Now, to understand it better, let us go through the jurisdictions, trademark infringement in different jurisdictions. That is like a comparative analysis. What were the case laws or provisions in United States of America, European Union, and United Kingdom when it comes to trademark infringement in these jurisdictions through e-commerce. Now, let us see first trademark infringement in USA jurisdiction. Now, as we have the Trademark Act of 1999, the United States that enacted the Layman Trademark Act in the year 1946 is the primary federal trademark statute of law in the United States. The act prohibits a number of activities, if you see, including trademark infringement, trademark dilution, and false advertising. In addition to that, as I told to you that they also enacted this Anti-Cyber Squatting Consumer Protection Act, which is not there in India. United States principally obliges the legal need of trademark law. It does not bring inside its domain contributed trademark risk. This has made US courts to depend for most parts on customary law standards when confronted with the issues of contributory risk for trademark infringement. Now let us try to understand through the again case laws, judicial pronouncements, which are very much relevant and essential with respect to counterfeiting of goods. The name of the case is Louis Vuitton versus Acnoc Solutions. This is the case of 2011 Ninth Circuit Court. In this case, the plaintiff Louis Vuitton sells luxury goods under the famous LV mark, which is a well-known mark, famous mark. Now, in this case, the defendant they provided web hosting services to websites selling counterfeit LV goods, and that's why the notice was served by the plaintiff for removal of counterfeiting goods, but they did not pay any heed to that, etc. ACNOC neither responded nor removed the infringing content from that particular e-commerce website, and that's why the plaintiff, as a last resort, that to file a suit for infringement, etc., for contributed trademark and copyright infringement. The jury found the defendant liable for contributory trademark infringement of counterfeiting and awarded the damages against the web hosting company and to other defendants. In this case, the court also see that whether there is also a liability, whether e-commerce website is also liable or not for this particular infringement. On appeal, the Ninth Circuit affirmed the finding of the contributory counterfeiting and infringement against the hosting company. When the case went into appeal, even it gave the relief in favor of this LV mark. Now, trademark infringement in EU jurisdiction in European Union. This is the one of the important case, Coty versus Amazon of 2020. The claimant Coty Germany is a perfume distributor and licensee of the EU trademark Davidoff. And Amazon, as we know, is the well-known marketplace offering third-party sellers the ability to place offers for sale in respect of their goods on Amazon's online marketplace. Amazon does offer a scheme whereby they will store third-party goods in their warehouse and arrange for them to be dispatched upon sale. And in this case, the Coty alleged that Amazon had infringed its rights in the Davidoff trademark by storing and dispatching infringing goods, namely bottles of Davidoff hot water. So they alleged that they stored these goods and their was intention was to sell this particular counterfeiting Davidoff hot water perfume on behalf of the third party seller on the Amazon marketplace. That's why the suit was filed by the plaintiff. However, it was held in this case that by the European Union Court of Justice. However, it ruled in favor of the Amazon, holding that the mere storage by Amazon in the context of its online marketplace of goods which infringe trademark rights, it does not constitute an infringement. So mere storage, etc., as there was no any particular malafide intention, etc., they had merely stored it, they did not sell it, etc., they are not held liable. Also, now when we talk about trademark infringement in UK jurisdiction, in UK, a trademark which was registered in the United Kingdom has its legal protection in England, Wales, Scotland, and Northern Ireland. The well-known law in UK, which is known as they have enacted the Trademark Act of 1994, which deals with the law relating to trademark in the UK. The registration process of trademark in the UK is accomplished through the UK Intellectual Property Office. As in India, we have the Trademark Registry Office through which trademarks can be registered. In United States, they have the United States Patent and Trademark Office. Similarly, UK have this office, UK IPO. Trademark, it is renewed after a period of 10 years. That is same in India also, it is renewed after a period of same 10 years. This is the relevant case in the UK with respect to counterfeiting of goods or trademarks through e-commerce. Name of the case is Cosmetic Variants Limited and Lush Limited versus Amazon.co.uk. Now in this case, Cosmetic Variants Limited, they are the registered proprietor and exclusive licensee of community trademark for the sign Lush for the cosmetics and toiletries including soap in class 3. As I said that trademarks are being registered in different classes of goods and services. So you'll find different classes of goods and services. And there is also an agreement for that. That is a nice classification of goods and services. Nice agreement, if you want to see. Nice agreement of 1957. So in this case, the claimants brought trademark infringement proceedings against Amazon, who is the first defendant, as well as against the second defendant. Now in this case, it was held that the Chancery Division of the High Court has upheld a claim by Lush Cosmetics arising from Amazon's use of the word Lush, which is a registered trademark, both as a Google AdWords. Now see, this is also another concern in the digital age, wherein there is also a violation of trademark by search engines by creating this Google AdWords, etc., while advertising any particular products or any keywords, etc. So without the permission of trademark owner, these search engines, Google, they cannot use this Google AdWords. Google AdWord and as a means of directing customers who search for it on the Amazon website to competing products. The judge held that such use, it amounted to infringement of the trademark. They also relied on a few Article 5 sub clause 1 of the directive of the European Union. The High Court has ruled that Amazon infringed this Lush trademark by using it in search engine advertising as well as on Amazon's own site in a case that has a wide-reaching implications for e-commerce. The judge also found that the two defendants were jointly liable since they joined together and agreed to work together in the furtherance of a common plan. So in this case also, the relief was given in favor of the plaintiff and they held that counterfeiting of goods, it shall not be sold through this e-commerce website. So apart from that, there are also other issues. If you see now, there is also jurisdiction issues in cyberspace. For example, now Amazon, it has various branches, etc., located in various countries. Now, what if the trademark is violated through e-commerce website, maybe in United States, and the person who is carrying on business in India? So, which law will be applicable? So there are also few tests for jurisdiction issues in cyberspace. For example, there is a minimum contacts theory or sliding scale test or effective test is there, which has to be which are very much helpful when it comes to jurisdiction issues in cyberspace. Also, there are few other issues. For example, these trademarks are being violated on social media where any logos, etc., are being used by any other person without taking any consent. So it also gives a threat to the infringement of intellectual property in cyberspace. So that's all from my end, wherein we discussed the concept of cyber squatting as well as the infringement of the trademark through cyberspace by selling any counterfeiting goods. So I would say when it comes to cyber squatting that we should have any comprehensive legislation as to that of the United States, and there is also need that we should also made certain provisions, enact certain provisions under the Information Technology Act of 2000 by amending it. Because last time it was only amended in the year 2008, and there is no any provisions have been inserted. Now, if you have any like questions, etc., so that I can answer. Yes, Archita. If there are any, because I could not see any audience over here, not able to see any audience.
If anyone has any question, please type it in the chat box for the YouTube live. We'll take up questions now.
How many participants are there? Because I cannot also see the list of participants here.
There are 15 participants.
Okay.
Any questions? So I don't think there are any questions as
Okay.
of now.
Okay. Thank you.
Um, as we conclude this enriching session on trademark infringement in the digital era, I extend my heartfelt gratitude to our esteemed speaker for sharing his profound insight and knowledge with us today. His lecture has undoubtedly added immense value to our understanding of the complexity surrounding trademark infringement in the digital era. I would also like to express my gratitude to each participant for your engagement and contribution to this discussion. Your presence has made this event truly intellectually stimulating. Let us carry forward the knowledge gained today and continue to explore and address the challenges posed by trademark infringement in the dynamic digital landscape. On behalf of Center for Study and Research in Intellectual Property Rights, thank you all for your participation and we look forward to welcoming you in our future events. Wishing you a wonderful day ahead. Thank you so much, sir, for your
Thank you.
enriching lecture. Thank you, everyone, for
Thank you,
attending.
Archita, and thank you to all the participants and once again organizing committee for inviting me for this lecture. Thank you.